everyone. Thank you so much for taking time off your afternoon to attend this very fascinating talk. I'm really excited that we have this talk by Professor Devika Hovell, who is an associate professor in public international law. She holds a doctorate from the University of Oxford, a master's of law from the New York University, and she's got a very long list of credentials. And most importantly, she's written this fantastic article in the Modern Law Review about the universal jurisdiction. And I really am excited to have her be here today and talk to us about this very fascinating topic. So without further ado, I will pass this over to Professor Hovell. I neglected to mention that she's at London School of Economics, which is so apologies about that.
Cheah, thank you very much. It's so fantastic to be here. I'm just loving being in Singapore. You're all very lucky to actually spend your days here. I just saw a family of otters playing by the lake. It's just idyllic. But here we are, and I am asking you to spend a little bit of time thinking and talking about universal jurisdiction. And Cheah said that actually it is something that a few of you, if I understand correctly, have been thinking about in your classes. So I'm going to certainly make sure I explain to those who aren't living and breathing international criminal law and transitional justice a bit about what universal jurisdiction is. But as the title that we've given to today's seminar denotes, it is about this notion of universality, which is this ridiculous fictional concept that we attach to international law, where universal, can suggest everything, everywhere, all at once. And I think that the issue becomes one more actually for those states who are expected sometimes, and in some quarters, to exercise this. And so this notion of universal can seem somewhat problematic politically, certainly for those in government. So the reason I became interested in this concept, a few reasons, but essentially it was me sitting in my office at the LSE one day and a colleague who works on Southeast Asian constitutional law, which here might be something that many people do, but certainly at the LSE is not so common, wandered into my office and said, there's a trial going on down the road at the Old Bailey. It's a Nepalese colonel who's being prosecuted for torture, but it's this thing called universal jurisdiction. I wonder if you want to pop along to the trial with me. Now, I'd worked at the ICJ a few years before where we'd had a case between Belgium and the Congo, which was about whether or not Belgium could prosecute a Congolese foreign minister, he was then the health minister by then, for crimes against humanity using universal jurisdiction. So I'd sort of engaged with it from the angle of the ICJ, where the conclusion there, it's a bit more complicated. Those of you who know, it actually was withdrawn, that particular claim, by the DRC, but actually some judges did pursue it. And one of the leading separate opinions by Higgins, Koymans and Bergenthal basically said about universal jurisdiction, not yet. It's not yet lawful. So we're in a bit of limbo land with universal jurisdiction. But here we were, and my colleague, Mara Malagodi, came into my office, said, do you want to pop down the road to this trial? Being an academic, I could just cancel all plans and wander down the road to the court, and actually ended up sitting there for 6 weeks. Again, being the academic, actually cancel all plans. This is fascinating. So I got to watch a universal jurisdiction case in action. And these cases are very, very rare. Again, you might say, why are we bothering spending an hour of our life speaking about this type of jurisdiction that actually is very, very rare? A few scholars have done the statistics. I sort of tried it myself. There's been about 70 to 80 cases completed worldwide using universal jurisdiction. So that's in history. So not very many. But it does open up a huge number of interesting issues insofar as understanding jurisdiction, understanding how international law engages with domestic courts and vice versa. So Colonel Lama, we have here. The case was Crown and Lama in the Old Bailey in 2016. It was a really difficult and problematic trial. The prosecutor started his opening statement. This is a story, and there was a jury, basically English jurors, sitting, judging the facts of this case, the prosecutor says to the jury in opening the trial, "This is a story of what happened a long time ago to two men in a country which is far, far away." It was unbelievable, like some fairy tale or some horror story, as it turned out to be. But trying to bring the jury in, sort of trying to say, look, this is really, you're going to find this a little bit not relevant to your day-to-day lives here. So bear with us, he seemed to be saying. And the question I had increasingly as I watched this trial unfold, as I watched the many, many problems that beset the trial, was what business of this is ours, sitting in London at the Old Bailey. The public gallery was empty. I sat there with Mara and the wife and two daughters of Colonel Lama. Apart from that, the gallery was empty. Now, many of you may in class, we inquire of our students, and kind of sat in one of my classes where, we say, well, what is the basis? What's the rationale for universal jurisdiction? And I don't know whether this term comes up in your classes, because it shocks the conscience of mankind. It's universal. Every country every state must take jurisdiction because it shocks the conscience of mankind. When I sat in this empty public gallery, I really didn't feel like mankind was that shocked by what was going on. It was a very neglected trial, certainly by the English public. And certainly on the 9th day of the trial, the juror handed up a note. One juror handed up a note to the judge. And there'd only been one note previously, and I got terribly excited. The jury's engaged. This is fantastic. And the judge read the note and said, juror number 4, yes, you have a cruise trip booked for next week. Yes, you are going to have to cancel that cruise. I'm terribly sorry. So they were just more worried about, when am I going to get out of here? I've got a cruise. But then on a few days later, another note came up from the jury. And this juror asked, the prosecutor just mentioned the words universal jurisdiction. What does that mean? And imagine my excitement. The judge said, look, don't worry about that. Basically, it just means that torture is one of those crimes that any state can prosecute, but under Section 134 of the Criminal Justice Act, basically it means that English courts have the power to prosecute here. Move on. And so we all moved on. And indeed, it was very much the court acting business as usual under a statute of the English Parliament. It was permitted that a public official or person acting in an official capacity, whatever his nationality, commits the offence of torture if in the UK or elsewhere he intentionally inflicts severe pain or suffering on another in the performance or purported performance of his official duties. So it didn't matter that this was conducted elsewhere. It didn't matter that Colonel Lama was not a national of the United Kingdom. The UK courts had jurisdiction to prosecute. So at the conclusion of the trial, Justice Sweeney addressed the jury and almost apologised to them. He said, look, it's relatively rare for so many witnesses to have required interpreters, and indeed for so many problems to arise in one case. I'm sorry that this has been so beset by problems. It's not our usual way of conducting ourselves, but there you go. Now, I understand she has very kindly set my article and forced some of you to read some of it in the MLR. In that article, I go into quite some detail about the problems that occurred in that case. And it's not what I'm going to speak about today. But again, given a few of you have endured it, and again, you'll be grateful with all this fine print. I won't go through all these various problems. But what it was suggesting to me was, look, this is not English law being prosecuted in English courts as we know it. There is something different about this trial. And so the very fact of the English court seeking to conduct business as usual was creating and responsible for some of these problems. The judge on occasion would say, we have such a fine system here in the UK. There were suggestions that the doctrine of command responsibility might be helpful. No, we don't have that as part of the English court system. And sort of shutting out where possible any sort of interference by these international legal concepts. The last problem in this sort of very heavily worded side that I'm not asking you to engage with is that problem, though, of outreach. And I just want us to engage with that because that is something I'm going to be speaking about a bit. As I sat there alone in the public gallery, I was very conscious that we were not really the main audience for this trial. Certainly not me. It was a problem that what I perceived to be the main audience for this trial were not being let into it. And just as a very brief sort of expression of this, my colleague Mara Malagodi has a strong connection to Nepal and has many friends and colleagues in Nepal. And she asked them just to at least send us the front page of every English newspaper, which I'm afraid was the only language I could engage with in this context. Every single newspaper the day after the verdict reported front page news, the verdict in this trial, which was actually that the jury could not reach a decision on one count and that they found the defendant not guilty on the other. So it was interesting to see how that was reported in the Nepalese press. Many of the newspaper articles reported that Colonel Lama had been given clean chit. He was promoted to brigadier the year following that. And, you know, it was said that a panel of experts had found him innocent, which is different from not guilty. But it was interesting to see how it was reported. This was the British press. This is the BBC News, but it's actually BBC Sussex. It's not even the main BBC website. A very, very small article somewhere deep in the internet in BBC Sussex reporting on the verdict. So this is where I'm getting into sort of what community was really engaged by this trial, by universal jurisdiction. And this is where, you'll forgive me, I'm going to get into some pretty legal talk in terms of jurisdiction. What is jurisdiction? James Crawford will be known to many of you. This is actually a quote from Brownlee's, his editorship of Brownlee's International Law, where he speaks about what jurisdiction is: the rightful authority to speak the law within a state's territory where there is a genuine connection between the subject matter of jurisdiction and the territorial base or reasonable interests of the state in question. So we tend to see a court can assume jurisdiction in these circumstances, where there's a genuine connection between the subject matter of jurisdiction and the territorial base or reasonable interests of the state in question. Now, I think you can see what's coming. Universal jurisdiction, by its very definition, there is not that connection. So universal jurisdiction, and this is the Princeton Principles, which is a certain document that has a definition of universal jurisdiction, is criminal jurisdiction based solely on the nature of the crime without regard to where the crime was committed, the nationality of the alleged or convicted perpetrator, the nationality of the victim, or any other connection to the state exercising such jurisdiction. So I'm suggesting in that title, it's sort of an exception to what we basically usually think of as a basis for a court to exercise jurisdiction. Now, unfortunately, though, it's therefore been defined by a negative, that it's just basically something that doesn't have the connection. The only way we have of making sure this isn't everything everywhere all at once, the only confining term here, I wonder if you can spot it, is, of course, the nature of the crime. So that's all we have to go on, the nature of the crime. So what does that mean? I mean, again, I know many of you, if I asked you, and I won't, this is your time off when you can just sit back and listen. But, you know, if I asked you what crimes are covered by universal jurisdiction, I'm sure you could tell me, you know, genocide, crimes against humanity, war crimes. Now, anyone want to throw in others? I mean, I've given the list on the board, but maybe piracy might have sprung to mind as one of the key crimes that is subject to universal jurisdiction. And certainly when in this ICJ case, Belgium and the Congo, even though judges who were really anti the idea of universal jurisdiction were willing to say, except for piracy. Now, when we think of the nature of the crime, though, it tends to attach that concept of heinousness, shocks the conscience of mankind. My son dresses up as a pirate. I don't know if you ever dress up as a pirate. He doesn't dress up as a genocide heir. Piracy is bad. I'm not saying it's good. Murder's bad, robbery's bad. Piracy, burglary, and board shorts. I don't know how you like to think of it, but it's not on that level of genocide. So what is it about the nature of the crime that connects piracy to all these crimes? The crime of aggression, I've even put a question mark after, because I'm not so sure I'd be as keen, for what it was worth, for domestic courts to be able to prosecute the crime of any domestic court to be able to prosecute the crime of aggression. Again, you can question me on that. Others might disagree. Drug trafficking, is that subject to universal jurisdiction? In fact, there's a treaty that says, yes, that there's a duty to prosecute or extradite regardless of nationality. It's a form of universal jurisdiction. But it seems we have to disaggregate a whole lot of things here. The nature of the crime is this sort of omnibus term that doesn't really tell us anything. What is it about the nature of the crime that might help us to make sure this is not everything everywhere all at once? How do we make this contain it? Now, this is I've struggled with, and luckily someone a bit cleverer than I has also struggled with this. So James Crawford, again, in his version of Brownlee's international law, in fact says that, look, it seems that attempting to derive a coherent theory for the extension of universal jurisdiction with respect to some crimes, but not others, is a futile exercise. Rather, it may simply be that such jurisdiction is extended on a case-by-case basis in customary international law. So what I am bringing you here today to talk about is actually, James Crawford says, a futile exercise. So bear with me. I'm being a bit iconoclastic here. I suggest that we can actually find some coherent way to draw together the threads of these crimes. Now, it's not original what I'm about to say. This is building on work of Klaus Kress, of Marko Milanovic, Neil Boyster, who've looked at these divisions of types of crimes. But I do think this is also helpful for us in universal jurisdiction. That we should draw this normative dividing line between domestic crimes, transnational crimes, and international crimes. And just to give away the ending, I'm going to suggest universal jurisdiction connects to international crimes and not to the other two. So, transnational crimes is a more difficult category for some of us. But Neil Boyster's, one of the leading scholars speaking about this type of criminal law. So he said it's more accurately described as non-hierarchical order of formally equal national centres of legal authority based on reciprocity, equality, and sovereign consent. So the reason why states want other states to adopt jurisdiction in relation to certain crimes that occur within their territory is based on this notion of reciprocity. It is national jurisdiction, but it's basically states protecting their own interests, mutually protecting their own interests. So there is that interstate dimension there. It's cooperation based on a mutual interest as a matter of international necessity. So perhaps draw the distinction here between, let's say, even piracy and genocide. So that interstate dimension isn't so much there with genocide, I would argue. It's not really in the mutual interest of interstate trade that actually, all states prosecute genocide. That is more this benevolent, comes more from this deeper sense of humanity. But then again, so if I'm going to come to the idea that, well, international crimes are subject to universal jurisdiction, well, what the heck are international crimes? Roger O'Keefe says, well, actually, we don't know that either. In his textbook on international criminal law, international crimes occupy a central place in international criminal law. Go figure. Yet there's no agreement as to what is meant by an international crime. No common understanding, let alone common definition of the concept exists. Schwarzenberger tried way back when to sort of give a suggestion as to 9 different types of ways of classifying international crimes. Kevin Heller more recently has written an article, What is an International Crime? I still don't think we've got to the bottom of this. I still find it a really interesting seminar in my international criminal law course where students are a bit befuddled that we actually don't know what the course is actually about. What is an international crime? It's a very difficult question to answer. So if we go back to our list that I'd put on that previous slide, I mean, I wonder if you could put these crimes into their category of domestic, transnational, or international. You know, perhaps we'd be happy to put the core crimes in the international box. Piracy, some might want to put in international. I'd suggest maybe it's more transnational. Terrorism, drug trafficking. You know, where do we place these? I don't know if it's something you feel comfortable already answering, but I do find it a helpful way of maybe disaggregating between the types of crimes that should attract universal jurisdiction. And essentially, what I suppose I think is that maybe it's not so much about dividing between these types of crimes, but maybe at the base of all this is actually the community that is most affected or interested in them. So if we go back to my definition, or Neil Boyce's definition, I should say, of transnational crimes, but I try to say it's got this strong interstate dimension. It's really about the mutual interests of states protecting, or states protecting their mutual interest. So I'd suggest that that's basically transnational jurisdiction really comes from the interstate community, that states tend to come together in treaties, for example, to determine when or whether they want each other to exercise jurisdiction in relation to crimes that occur within their territory or by their nationals. You know, certainly, obviously, the domestic community is concerned with domestic crimes. It's even problematic to me that, you know, this case, Crown and Llama, you know, what does Crown signify? It's because it's on behalf of the domestic, well, the domestic sovereign, really, isn't it? And so in Singapore, I don't know how its criminal cases are described, but in some states it's the people and, or, you know, state versus. So, you know, we find that in many states, it's actually very clearly that crime is prosecuted on behalf of the domestic community. But there's no doubt to me that sitting in that domestic courtroom for Crown and Llama, that the Crown Sovereign, that as it was, Her Majesty, really wasn't the public or sovereign that was interested in the prosecution of this particular crime. What is the community on whose behalf universal jurisdiction crimes are prosecuted? So, you know, it also, talking about this ties into another issue and a broader issue. And I wonder if you can or would be happy to follow me this far. So, you know, we talk and are increasingly speaking about this international criminal justice. And I ask my students, is there such a thing as an international criminal justice system? I mean, I've tried to, forgive me, and I'm not at all an expert in the Singaporean justice system, but, you know, the criminal justice system here, there's a clear hierarchy of courts through which a case goes. There's a clear sense of what the domestic criminal justice system looks like. But when we look at international criminal law, you know, there's this hodgepodge of courts, if you like. And I'm sure you're learning about the ICC, the hybrid tribunals, like the Special Tribunal for Lebanon, the Special Court for Sierra Leone, extraordinary chambers in the courts of Cambodia, the Kosovo Specialist Chambers. But how do all these courts fit together? The ad hoc tribunals for Rwanda and Yugoslavia. There's not really a system necessarily, but I want to throw into the mix that actually when domestic courts exercise universal jurisdiction, they're not part of the domestic criminal justice system in doing that. They are part of the international criminal justice system. And while you might say, well, who cares? You know, if they're basically sitting in a UK court, as it is in Crown and Llama, prosecuting a UK statute, it does matter, Because if you've got a sense as a courtroom of the community that you're engaging with, that has all sorts of implications for the trial itself, including, very controversially, the jury. Who should be on that jury, for example? Certainly insofar as what language should this judgment be published in? Who should be invited into this courtroom? What languages should be in the public gallery? Should there be interpretation? I mean, you know, there's so many dimensions that I saw were not present in our English courtroom when it was being prosecuted that led to what I would argue, if we see universal jurisdiction as part of the international criminal justice system, if we think there is a point to international criminal law, if we think there are objectives that are satisfied, and again, this will be something particularly my transitional or your transitional justice students will be much more aware of, and hopefully us lawyers have a sense of why we're doing it. Those objectives were absolutely not fulfilled in Crown and Lama. None of the objectives. So it matters sort of where we place this type of jurisdiction. Now, Karim Khan, in his most recent policy report, and indeed in his annual report, I was interested, he was talking about the ICC as a hub, not an apex. Now, we often make the mistake of seeing the ICC as at the apex of the international criminal justice system. Of course, you will know as law students, international criminal law students, it's supposed to be the court of last resort. What's supposed to come first? Domestic courts. Okay, so if it's supposed to be that domestic courts are leading the way in this international criminal justice system, then there's got to be some sense of their role in that system. And I think Karim Khan seems to be making it one of his key initiatives to really start to explain this notion of the connection of domestic courts and the way in which the ICC should be assisting, indeed, domestic courts, even with universal jurisdiction. So again, this is just a side point. So coming back to my argument, it is really about that at the base of this should be some sense of the community affected by these trials. And Hannah Arendt said it, well, said it far earlier than I did in her pretty interesting book, Eichmann in Jerusalem. So she says the common illusion that the crime of murder and the crime of genocide are essentially the same. There is a common illusion that the crime of genocide and the crime of murder are essentially the same. But the point is, and the point of the latter, genocide, is that an altogether different order is broken and an altogether different community is violated. So many of you who've read it will remember her quote about the Smith family. So, you know, the Smith family are affected by certain crimes, but these crimes of genocide, crimes against humanity are, as it says on the tin, crimes against a different community, against humanity even. So in my modest work, I've been trying to look at this notion of community and trying to work out what communities are affected. And in fact, the answer is not as simple as it is just the international community, partly because what on earth is the international community? So we have another problem. Humanity, what is humanity? That it's a very difficult community to describe. It's actually a community that is being forged, some might suggest doesn't even exist. So this notion of communities is a difficult one. And in my latest piece, I am suggesting that actually there are more than one community at the heart of these trials. And I'm trying to work out a way to bring that together in some legal coherent theory. So perhaps you can help me with that as to whether you see any sense in the direction I've taken so far. So there's four main communities that I see are implicated here. Certainly the international community. Also the interstate community, so I'm not saying that it's just transnational law that the interstate community is concerned with, the victim communities, and of course the domestic community of the prosecuting state. And I'm trying to explain the different ways in which these communities are relevant to universal jurisdiction. So in terms of the nature of the crime, that's where the international community is most pertinent. That universal jurisdiction under customary international law, and those clever clogs in the audience will be saying, yeah, but there are lots of treaties where states come together and recognise a form of universal jurisdiction, for example, in relation to drug trafficking. And I would definitely agree that drug trafficking is not an international crime. But I want to draw a distinction between treaty-based universal jurisdiction and universal jurisdiction under customary international law. And if you want to follow me or to this next step, I'll explain why. It's interesting, universal jurisdiction, if states come together in a treaty to recognise universal jurisdiction, and that treaty only has 60 states parties, for example, we might say, well, how can 60 states come together and give themselves universal jurisdiction? And I'd argue that in relation to certain crimes, such as the non-international crimes, drug trafficking, universal jurisdiction would only apply as between those states that have been parties to those treaties. Whereas if we're talking about an international crime, it doesn't matter if there's only 4 states parties to that treaty. They can give themselves universal jurisdiction in relation to international crimes. And that's because ultimately our source is customary international law. And forgive me, I realise how technical I'm getting into that sources area. But it does, I'm trying to say it does have implications, what I'm saying. And the Pinochet case, when you read that through the lens of what I'm trying to say, it's quite interesting because, you know, the Pinochet case, for some reason, even though the UK courts didn't have universal jurisdiction over Pinochet, there's very little that's said in that case. For some reason, it's associated as one of the main cases on universal jurisdiction. And only one judge really spoke about universal jurisdiction and actually said there is no universal jurisdiction in customary international law in relation to torture. But there was another interesting moment where one judge drew a distinction between single acts of torture, no universal jurisdiction, and systematic torture, which there would be universal jurisdiction in relation to. And I'm putting words completely into their mouth, but I'd suggest that what they were saying was that there's a distinction between the international crime of torture, more like a crime against humanity of torture, and, forgive me, I know this sounds harsh, but the single instance, which is more, not so much the international crime under customary international law. So international community is relevant that in order for universal jurisdiction to follow, there must be a shared consciousness that the conduct amounts, and I'm using the term from the Rome Statutes preamble, from the recent The Hague, the Ljubljana Convention on Mutual Cooperation, which actually where states do give themselves universal jurisdiction in relation to crimes against humanity, war crimes and genocide, but it's only been ratified by so far, I think, about 30 or so states. But the reason why those 30 or so states can give themselves that jurisdiction is because it exists, I'd argue, more generally, that shared consciousness that conduct does amount to an international crime. The interstate community, though, of course, is necessary. That basically, I'd argue, why in this case? Because they've agreed there has to be a burden sharing in the enforcement of international criminal law, and that domestic courts are one of those entities that should be engaged in the enforcement of international criminal law. But you do require those states to give their consent, to lend their state courts to the role of prosecuting international crimes. So in a way, what I'm opening up there is the idea that states have discretion, aren't I? It's almost that they've got a right to do this, but they don't have to. But that's where the victim community come in. The victim community can introduce more of an obligation upon states. And there we connect to human rights, to the right of access to justice. That in certain cases, victims can impose on states, maybe by their very presence within a state's territory, an obligation on that state to give them access to justice, to prosecute crimes of genocide, crimes against humanity and war crimes. Now, that if I'm saying that's a human right, though, it's not an absolute right. So it's not that every state that a victim comes to has to prosecute. We know in human rights there's this doctrine of proportionality, that actually where the compliance with the human right disproportionately impacts the legitimate rights and interests of a state, then they can balance those rights and interests. So actually there is a right for states, even if they've got that obligation to give access to justice, to work out whether they need, where it would disproportionately affect those states' legitimate aims and interests. So do you see there that there's a whole lot of talk about the selectivity of international criminal justice, a whole lot of discussion about, it's just political. But I'm saying, lawyers, we can do this. Actually, there can be some legal checks and balances that can be introduced to this discretion using, international law and legal principles in general. So in my article, this is where I try and give a more pithy, but it's still very wordy, suggestion as to what is universal jurisdiction. Beyond the nature of the crime, universal jurisdiction is essentially a license granted by the interstate community to universalise the right of access to justice for victim communities, enabling third states to prosecute certain heinous crimes of concern to the international community where this does not disproportionately affect the interests of the prosecuting state. Forgive me, it is wordy, much more wordy than nature of the crime, but I think it gives us a little more guidance as to when states may and sometimes must exercise universal jurisdiction. Now, I tried to do this yesterday. Momoka was very kind, gave me a bit of an extension on my slides. I'm actually not sure how helpful this is, but this is, and I'm going to brush right past it, but I think I can do a flow chart which tells states when they don't have to prosecute, when they may prosecute, and when they must prosecute using those tools. Now, in the article, though, what I try and do, because this is ultimately discretion, is suggest some criteria that basically states the DPP, the Attorney General, whoever the authority is, who decides on whether to take these universal jurisdiction cases, because my own research and others reflects that actually it's almost always victims that are trying to push these cases. It's not states that are lawfaring all over the place and desperate to do and exercise universal jurisdiction at all. And indeed, there would be many problems with that being the approach. It's almost always victims that are trying to push these cases. And there's certainly a set of criteria using, what I've discussed before, the consensus as to the seriousness of the crime, the idea that there are gaps in the enforcement, the danger that the offences wouldn't otherwise be prosecuted, that problem of impunity. There has to be a desire by victims for access to justice. You have to check that the vulnerability and security of those victims and witnesses in any case. The location of the accused becomes relevant. So if the accused is in your territory asking for that, that will be relevant whether you have a capacity to prosecute the accused. Roger O'Keefe wrote a very famous article on universal jurisdiction. I entirely disagree, controversially, with his idea that you can separate, he says, in absentia from universal jurisdiction. I think actually they do come together. The location of the accused is relevant to whether or not a state should or must exercise universal jurisdiction. And then here we have the proportionality equation. So legitimate interests of a state, the effective administration of justice. If there simply isn't enough evidence, access to enough evidence to prosecute that individual, a state should not prosecute. If they don't have a capacity to get their hands on relevant evidence, they shouldn't prosecute. That would be legitimate interest in maintaining the effective administration of justice. The impact on the standing, reputation and diplomatic relations of the prosecuting state can be put in the balance. It's difficult regionally and particularly to prosecute those in a neighbouring state, for example. It might have such an impact on your diplomatic relations that actually that might go against the balance of prosecution. Certainly affordability of the cost of prosecution. There is certainly, if we look at the map of those who have prosecuted universal jurisdiction crimes, it will be all developed states, almost no developing nations, and some bring a TWAIL, and I'm in the home of some of the TWAIL scholarship, but some bring a TWAIL analysis and say universal jurisdiction is imperialist. And sorry, I'm not saying that's what certainly your colleagues say about it. In fact, I've used the work of your colleagues to say that's not what TWAIL's about. That actually it's because developed states might be able to afford prosecution more than developing and least developed countries, that they should assume a greater burden for that. But they've got to be aware they're prosecuting not on behalf of their own interests, but on behalf of a different set of communities. And that has to be factored into the trial as well. I feel as if I've given out a lot of information. Forgive me. It is me struggling with an issue. And in a way, I'm trying to sort of explain where I've got. And I'd be really interested to know whether this resonates at all, and in particular, whether it doesn't, and any critiques you've got. But thank you very much for coming along today and having a listen.
Thank you so much, Professor Hovell.